The subcommittee will come to order. At the conclusion of yesterday's opening statements, the chair called up the discussion draft of targeting rogue and opaque letters, and the bill was open for amendment at any point. Are there any bipartisan amendments to this bill? Are there any other amendments to this bill? The chair. And the chair has an amendment of which I am will offer and withdraw. The bill currently requires the sender of a demand letter to. Do we have to hand out the amendment? Yeah. The clerk will report the amendment. That's what I was looking for.
Which number is the amendment, sir?
It is PDL 301.
Amendment to the committee print offered by Mr. Terry of Nebraska.
Thank you. And I will recognize myself for 5 minutes. The bill currently requires the sender of a demand letter to identify the person asserting a patent right, and also requires the identification of any parent entity or ultimate parent entity of that person unless the person asserting the patent is a public company. The purpose is to prevent one person or company from hiding behind hundreds of shell companies in order to evade detection or to obscure their pattern of deceitful behavior. The exception for public companies is because their corporate structure, meaning any parent companies, are already public and more easily discovered. The reality of large companies, however, is that they may hold thousands of patents across a number of holding companies or affiliates, and some of those holding companies may not be public companies. In these cases, it is more accurate to require the sender to identify a single affiliate that is authorized to represent the patent rights holder, rather than the parent company, because the parent company is not always the rights holding entity. The amendment allows the sender of the letter to identify either the person asserting the right or the affiliate who is asserting the right on their behalf. Additionally, the amendment will extend the exception to not have to have to identify one's parent company if you are a public company, because your corporate structure is already public, but also allow you to omit the name of your parent company if you are an affiliate of a public company whose name is reasonably identifiable from your name. This amendment is meant to accomplish the same purpose of preventing a bad actor from hiding behind multiple shell companies without confusing the recipient as to who holds the patent rights. However, because negotiations on how to best effectuate this are going on, I offer and withdraw this amendment. As we move to full committee, we have all, of course, welcome any and all comments on this issue. So, anybody else? I yield back my time. Anybody to discuss this amendment?
Yeah, thank you.
Gentlelady from Illinois is
Thank you,
recognized.
Mr. Chairman. I just want to say that I certainly agree with the concept of not letting, not hiding behind a shell company and the disclosure. Not sure that the amendment that you had got there. I know it's withdrawn, but I'm hoping that we'll be able to work between now and full committee. And I would appreciate very much if you would work with me and the minority to come up with an amendment that addresses this particular issue. And I yield back.
Thank you. And to answer your question, of course, we would love to continue our discussions. It started in a bipartisan manner, and we're going to continue that until we get a bill that we can mark up in full committee. No further requests on this amendment. Unanimous consent to withdraw the amendment. So ordered. Clerk, I have an amendment at the desk. Terry 088.
Amendment to the committee print
that.
offered by Mr. Terry of Nebraska.
And without objection, dispense with the reading. Please distribute the amendment. I will recognize myself for 5 minutes on this amendment. This amendment, it's the first part of this amendment, strikes and replaces the affirmative defense language in the draft. The language contained in the amendment reflects an earlier agreement by the stakeholders. The language in the underlying text was intended to achieve the same result as that which is in the amendment. The language was changed merely for grammatical purposes, but some stakeholders are concerned that the language would limit the FTC. By striking the phrase, quote, shall be sufficient, end quote, and replacing it with the phrase, quote, which may be demonstrated by, end quote, we clarify that the FTC may look at the totality of a sender's letters and determine whether their usual course of business is to send non-violative letters and may also look at other factors. The second part of this amendment is really more of a technical amendment. The Vermont AG has offered thoughtful comments at both of our hearings, and as a result, there are a number of changes in the base text from the first draft we released earlier this year. One of the changes the Vermont AG requested was to be able to get civil penalties as opposed to compensatory damages. We thought this was a reasonable request. This amendment drops the unnecessary phrase, quote, on behalf of recipients who suffered actual damages as a result of such violation, end quote, in that civil penalty section as suggested by the Vermont AG. Now, I yield back the rest of my time. Does anybody else wish to claim time in opposition or discussion? Mr. Waxman, you are recognized for...
Thank you, Mr. Chairman. I appreciate the effort through this amendment to clarify the state civil penalties portion of the bill. I would support that portion of the amendment, but the proposed change to the affirmative defense remains still very problematic, as are a number of other provisions in this bill. The bill contains a number of safeguards for patent holders that send legitimate patent assertion letters, including requirements that the sender has engaged in a pattern or practice of violating the statute, and that the sender has sent the letters with knowledge that the representation made were false or misleading. But the affirmative defense in this bill, even as modified by this amendment, says that because a sender hasn't violated the statute before, it couldn't be violating the statute now, even where all the evidence points to the contrary. In this way, the affirmative defense creates a loophole that could eviscerate the rest of the bill. Even if this amendment deleted the affirmative defense, other provisions of the bill not addressed by the amendment continue to raise serious concerns. The bad faith element is a stark deviation from consumer protection law. Under its traditional authority, the FTC can obtain an injunction without proving any element of knowledge. To obtain an injunction under the bill for the enumerated bad acts and practices, the FTC would have to prove that the violation occurred and that the sender knew its conduct was deceptive. This requirement makes enforcement much more difficult than current law. Also, FTC staff has stated very clearly that the bad faith element makes all disclosure requirements effectively unenforceable. This bill also severely constrains the state's ability to combat deceptive demand letters by preempting a number of state laws as well as state common law that address these letters. Moreover, the state's ability to enforce this statute is limited by the arbitrary cap on civil penalties that can be collected by all states for violations of this statute, and the link between civil penalties and actual damages suffered by recipients. These are major problems that make the bill, as I see it, unworkable, and I would urge my colleagues to vote against this bill. And I yield my time to Mr. McNerney.
Well, thank you. I want to thank the chairman for his work, especially in a bipartisan way to put this forward. It's an important issue. I'm a patent holder. I want to make sure that my rights are protected, as well as making sure that the law doesn't adversely affect innovation in this country. But as I've seen, the AG in Vermont had a number of specific changes. The Oregon also had a number of specific changes. I don't think we're ready to put this bill forward. So, I thank the chairman. I look forward to working on a bipartisan way to make this bill better as we go forward to the committee. And I yield back.
Be over there.
You want my time or you want your own?
Oh, my own. I'm sorry.
Okay. Yield back my time.
Very good. Anyone on this side requests time on this amendment? Gentlelady from Illinois is recognized for 5 minutes.
Thank you, Mr. Chairman. Well, I am not going to oppose this amendment. It does not really begin to adequately fix the bill. Even with this amendment, the affirmative defense provision, as stated by Mr. Waxman, would allow a bad actor to avoid liability simply because he didn't have a history of sending deceptive letters. The amendment doesn't even specify that the letters have to relate to patent assertion. If an entity has a history of sending any letters that do not violate the provisions of this bill, the entity could avoid liability for even the most egregious patent demand letters. The amendment would also strike the important language from the bill specifying that state attorneys general can obtain civil penalties on behalf of their citizens who receive demand letters that violate this act. Beyond the failure to adequately address the affirmative defense provision, this amendment also does not address other problematic aspects of the bill. It doesn't fix the bill's preemption of more protective state laws. It doesn't address the bad faith definition that would require the FTC to determine the intention of the bad actor in order to provide relief to small businesses and entrepreneurs, again, as Mr. Waxman stated. And this bill does not address all of the deceptive conduct we have already seen in patent demand letters. For example, I received a copy of a letter sent to a bank asserting infringement of a patent portfolio covering ATMs. The letter provided no information about the patent portfolio or the alleged infringement other than to say that the bank, quote, has at least one ATM, unquote. The letter made a quote, special one-time limited offer, unquote, to license the patent for $2,000 per ATM, which must be accepted within 14 days of the date of the letter. Later, the bank received another letter increasing the cost to license the patent to $5,000 per ATM. The letters gave an unreasonable deadline for a response to its, quote, special one-time limited offer, unquote. They also demanded a licensing fee without any basis for the amount demanded and then arbitrarily increased the fee. By any reasonable standard, those letters are unfair or deceptive, but are not prohibited by this bill. Finally, I would like to comment on recent press reports and statements made about how the latest draft of this bill was crafted. It has been suggested that any concerns raised were either last minute or surprising. While the majority did seek to bring some stakeholders together over the last month, the minority staff continually raised concerns that several relevant stakeholders were not part of those conversations and did not have access to the draft language. In addition, general concerns of state and federal enforcers were shared throughout the process, and specific concerns were raised as soon as those stakeholders were able to see the actual language. In closing, while I will not oppose this amendment, I continue to oppose the bill. As I said yesterday in my opening statement, I hope, and I sincerely mean that language can be crafted that actually addresses the problem that this committee has now been considering for quite a while, ever since the issue was brought before the Oversight Committee last December. I look forward to working with the chairman and the majority in the coming week, and I yield back.
Thank you. Gentlelady yields back her time. No one on the Republican side, majority side, so the gentleman from Vermont is recognized for 5 minutes.
Thank you very much, Mr. Chairman. I want to thank you and Chairman Upton. We've had a good thing going on this patent troll situation. And just a little context, because a lot of us have reservations about this particular thing. But little context, as a result of the work of this committee, the House of Representatives passed a very good patent troll bill with a vote of 325 to 91. And that was a product of a lot of hard work by a lot of people on both sides of the aisle. Unfortunately, that's stalled in the Senate. It's been taken off the Senate calendar. But that's really the touchstone for me of a comprehensive approach to give relief to the folks in your district and mine who are getting hammered with this rip-off patent troll situation. The reason, unfortunately, that I can't support this, but do appreciate the effort going forward. By the way, I want to say another thing. There were 8 stakeholder meetings, and we were at them. You know, everybody's not at them, but I really did regard it as a very serious effort to try to get the stakeholders to reach an agreement. But the problem that I have going forward is because I checked with my folks in Vermont, as we would all do. And Vermont's been out in the lead. This Jerry Tarrant, who has a company that's done very well, has been hammered repeatedly with this. And he doesn't see this as providing any relief. And that's particularly true in Vermont because we have an active Attorney General and we have an active legislature that's put forward protections that would be greater than what exists in this particular legislation. So the preemption issue here would actually take away some tools that Vermont has developed. So obviously, from my perspective, that's not a good thing. And that goes, by the way, for my WebMD, which is Jerry Tarrant's company, and Lincoln Street, which is a small nonprofit that helps kids with disabilities. The 2 issues in here that our AG pointed out, the bad faith and increased knowledge, as others have reported, is an issue because it makes it very difficult to prove it, and it makes it so difficult to prove that other responsible people who've been involved in this don't see this as really enforceable. The other issue is the affirmative defense position really creates an impossibility when it goes to court. So the preemption, the affirmative defense, and the bad faith all actually, from the way I see it, weaken what we did as a House of Representatives when we passed the overall patent troll bill. You know, one of the difficulties here is there really are competing interests. Some of our larger companies that are legitimate players want to protect their patents as they should, but the smaller folks are getting ripped off, and how do we protect them without encroaching on legitimate patent rights? And that was the effort that was made in some of these stakeholder meetings, but I don't think it got finally worked out. And one of the other apprehensions I have, and this is a judgment call, is that if we pass this, there's a lot of folks who are out there that are opposing the legislation that we passed in the House by that big overwhelming vote. And the passage of this is going to become an excuse for the Senate not to act on what is a comprehensive bill that was a bipartisan strong vote passed by the House of Representatives. So let's try to keep working on this, but those are the problems that I see as undercutting the progress that we made already with the legislation the House of Representatives passed. So I yield back.
Gentleman yields back his time. Any other requests? There are no other requests for time on this amendment, and I'm asked unanimous consent to withdraw the amendment. I'm sorry. If there's no further discussion, sorry, I was misinformed. If there is no further discussion, the vote occurs on the amendment. All those in favor say aye. Aye. All those opposed say no. No. In the opinion of the chair, the noes have it. The ayes. Jeez. I heard 2 noes and a whole bunch. Coffee and obviously not enough. The ayes have it, and the amendment is agreed to. Are there any other amendments? So, hearing no other amendments, the question now occurs on forwarding the discussion draft to the full committee as amended. All those in favor say aye. Aye. All those opposed say no. No. In the opinion of,
I'd like a roll call vote.
we'll go right to the roll call. The clerk will call the roll.
Mr. Lance. Mr. Lance votes aye. Mrs. Blackburn. Mr. Harper. Mr. Harper votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Kinzinger. Mr. Bilrakis. Mr. Bilrakis votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Long. Mr. Long votes aye. Mr. Barton. Mr. Upton. Mr. Upton votes aye. Ms. Schakowsky.
No.
Schakowsky votes no. Mr. Sarbanes. Mr. McNerney. Mr. McNerney votes no. Mr. Welsh. Mr. Welsh votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Mr. Dingle. Mr. Dingle votes no. Mr. Rush. Mr. Matheson. Mr. Matheson votes aye. Mr. Barrow. Mr. Barrow votes aye. Ms. Christensen. Mr. Waxman.
No.
Mr. Waxman votes no. Chairman Terry.
Aye.
Chairman Terry votes aye. Mrs. Blackburn. Mrs. Blackburn votes aye.
The clerk will report the result.
Mr. Chairman, on that vote, there were 13 ayes and 16 nays.
The ayes have it, and the bill is agreed to. The clerk will...
My apologies, 13 ayes, 6 nays.
13 ayes, 6 nays. The ayes have it, and the bill is agreed to. All right. The car bill. The chair calls up 4013, H.R. 4013, and asks the clerk to report.
H.R. 4013, to direct the National Highway Traffic Safety Administration to establish a program allowing low-volume motor vehicle manufacturers to produce a limited number of vehicles annually within a regulatory system that addresses the unique safety and financial issues associated with limited production, and to direct the Environmental Protection Agency to allow low-volume motor vehicle manufacturers to install engines from vehicles that have been issued certificates of conformity.
Without objection, first reading of the bill is dispensed with, and the bill will be open for amendment at any point. So ordered. The chair recognizes himself to offer an amendment in the nature of a substitute, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 4013 offered by Mr. Terry of Nebraska.
Without objection, the reading of the amendment is dispensed with, and I will recognize myself for 5 minutes in support of the amendment. The original intent of the legislation was to enable small automakers to provide a limited number of specialty vehicles, both replica and non-replica vehicles, to customers nationwide. Replica vehicles resemble cars older than 25 years, while non-replica would cover newer vehicles such as sports cars. With this amendment, the legislation now only applies to replica cars. As noted, these are motor vehicles produced in small numbers and intended to resemble vehicles from previous generations. Replica 1932 Fords and 1965 Cobras are perhaps the best example of these cars. These are collector cars that are primarily used in exhibitions, parades, and for occasional transportation. As the nation's stock of original classic cars has dwindled, the desire by hobbyists to own such historic vehicles has grown. National Highway Traffic Safety Administration has one safety regime for regulating motor vehicle manufacturers that treats all companies alike, whether they are produced by the millions of cars or just 5. This legislation would establish an alternative regime for specialty automakers. It would hold low production manufacturers of collector cars to NHTSA equipment standards, lighting, brakes, tires, for example, while exempting them from vehicle-based standards. The companies would register with NHTSA and annually report their production levels. They would also subject NHTSA to oversight, and the vehicles would be subject to recalls and remedies. Unlike the predecessors, the replica vehicles would be clean cars. They would meet current model year emission requirements for the U.S. Environmental Protection Agency and California Air Resource Board, including installation of onboard diagnostic systems. The vehicles would also be covered by engine emission warranties. That concludes my statement, and I yield back my time. Are there any other people seeking? The gentlelady from Illinois is recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment makes a number of changes to the introduced version of the bill. Some improve the text, others may not. While I do not intend to impose this amendment, it shows once again why this legislation should have gone through regular order. For example, this amendment deletes language requiring recall notifications at the same time as including provisions limiting liability. Without a proper hearing or two, or at least time to explore the issue with relevant stakeholders and clarify the matter, one could conclude that if these replica cars are in an accident, the injured passengers and other motorists could be without recourse. Another question is why these replica companies have not tried to use the existing NHTSA and EPA waiver processes. These existing mechanisms do work. In fact, just this week, NHTSA issued a final rule allowing a regulatory exemption for certain cars that have been modified for disabled drivers to prevent people from being ejected during rollovers. These replica companies may not get all that they seek in waivers, but through hearings, we could explore why they have not at least tried to go that route. This amendment also does not address how this bill interacts with state law. Several states place very responsible restrictions on replica vehicles. It's unclear why similar restrictions are not included in the bill and what effect this bill would have on state protections. For example, Delaware's law states that these vehicles shall only be used for participation in club activities, exhibits, tours, parades, or similar uses. In no event are they to be used for general transportation or to drive in excess of 1,000 miles per year. Oregon has a similar law limiting use to events like exhibits and parades. There are a number of additional questions that I feel should be answered before ever considering this bill. Some of those include: how many of these vehicles without safety protections will be on the roads? Each low-volume manufacturer is limited to 1,000 vehicles, but there are no limits on the number of manufacturers. Another question: will any of these cars have airbags? What about seat belts or other alternative safety systems? If not, should passengers, including children, be permitted in these cars? Can NHTSA realistically review all requests in 60 days? If not, should the requests be automatically approved? What happens if there's an accident? A replica and a modern car collide. Who bears the liability? Are we going to allow replica manufacturers to be considered like the new GM? What additional pollution burden will these cars add? The bill exempts them from state inspection and emission controls that are in place to protect our air. I could never vote to support a bill with so many unknowns, especially when the public health, environment, and driver, passenger, and pedestrian safety are on the line. And I yield back.
Anyone else seek recognition on the base amendment?
Well,
All right.
Mr. Chairman,
Mr. Waxman is recognized.
I want to be recognized to strike the last word.
This gentleman strikes the last word. You're recognized for 5 minutes.
These concerns that I want to express are not directed just to this amendment, but to the bill itself. I understand that there have been changes in this amendment that have been worked out with the automobile industry, and the bill would only exempt replica cars from important safety and environmental standards and no longer exempt non-replica cars from those standards. Well, that's a good thing. However, among its other provisions, this amendment deletes bill language requiring the replica manufacturers to be responsible for recalls and other required notifications regarding defects. It also includes language ensuring that an original automobile manufacturer will never be liable under any law because that original manufacturer gave the replica manufacturer the design and/or rights to build its replica. That's not a good thing. Perhaps more concerning, this amendment does not address the fundamental problems with the underlying bill. It does nothing to ensure that we do not have thousands of unsafe and polluting cars on our roads. As I mentioned yesterday during my opening statement, vehicle safety has improved dramatically over the last 50 years. I'd like to show a video of what happens when a car meeting 1959 vehicle safety standards collides with a modern 2009 vehicle. Could we, as we say, run the video? This Back to the Future video indicates that in the 1959 car, the windshield's gone. The front end is totally crumpled, and the driver dies. In the modern car, the windshield stays in place, the front end absorbs and diffuses the crash force, and the driver breaks his leg. I'll not oppose this amendment, but let's not allow this huge step backwards for auto safety to occur. And I urge a no vote on final passage of the bill. I yield back the balance of my time.
Thank you. And while discussion is still occurring on the base amendment, I know, Fred, you...
I think Mr. Barrow is going to go next, then I'm going to
Yes.
offer an amendment to the
Perfect. We're all on the same page. Mr. Barrow, you are recognized for 5
Move to
minutes.
strike the last word, Mr. Chairman.
You are recognized for 5 minutes.
Thank you, Mr. Chairman. I've been a co-sponsor of this bill for a couple of Congresses now because I think it'll be a job stimulator, because I think it'll facilitate the pursuit of happiness for hundreds of car enthusiasts. Sure. Because I think hundreds of car enthusiasts and tinkers around the country are going to enjoy the benefits of this law. I admit to having mixed emotions when I learned of the markup earlier this week. Yes, it is. Is this better? Of course, I think this is a worthy bill, and I'm happy to have a chance to move forward. But I hope that moving outside the bounds of regular order doesn't spoil our chance to build a bipartisan coalition that can carry this bill all the way to law. I plan to support it in any case. Today, a car enthusiast can go to a low-volume manufacturer and buy a replica car that is fully assembled except for the engine. The car enthusiast can then install an engine himself. These cars are replicas of old cars, so by definition, they often don't meet modern-day safety standards for crumple zones and bumper safety. But the consumer is well aware of that. NHTSA allows it, and it happens every week around the country. This bill would simply allow the low-volume manufacturer to install the engine for the consumer. I believe that the people who are interested in owning these cars are already getting their hands on them and are driving around as we speak. And I don't believe that allowing the vehicle manufacturer to install engines in these bodies is going to result in a huge increase in unsafe cars on the road, as some of us have suggested. On the other hand, I think it's just as plausible that having the vehicle manufacturer install the engine instead of the owner in his home garage might result in a net safety increase. In any case, this bill is pro-business. It's a very small market, and the bill preserves that principle. I appreciate my colleagues' consideration. I yield back.
Gentleman yields back. Anyone else on the base? Seeing none.
Mr. Chairman,
Gentlemen.
I have an amendment to the amendment in the nature of a substitute.
Which number is the amendment?
I don't know which one it is. It reduces the number from 1,000 to 500.
Amendment.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 4013 offered by Mr. Upton of Michigan.
Gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, what this amendment does is we listen to some of the concerns. This is a niche market, let's face it. These cars are not used for regular transportation, ferrying kids to school, going back and forth to work. Often they're in parades, they're in auto shows, they're things of beauty. They're old cars, and it's remarkable to see these at auto shows across the country. What my amendment to the amendment to the nature of a substitute does is it reduces from 1,000 vehicles per year to 500. So it really makes it much more of a niche market than it is perhaps a larger one. It reduces the number of vehicles. It's pretty straightforward, and I would like to think that we could accept this amendment and then move forward with the amendment in the nature of a substitute, and would ask my colleagues to support the reduction from 1,000 vehicles to 500.
Very good.
Per year. I yield back.
Full committee chairman yields back. Is there any other further? The gentleman from California, for what purpose?
Strike the last word.
Gentleman's recognized for 5 minutes.
I'd be in favor of reducing the number of vehicles that could be subject to the proposed safety exemption. That's what this amendment would do. That's a good first step addressing the issues with this bill, but it's only a small step. It makes a terrible bill just a little less terrible. We shouldn't be compromising, in my view, vehicle safety and the environment so lightly and with so many questions still lingering. The amendment, by the way, strikes 1,000 and inserts 500. On top of everything, I'd like to point out or reiterate that under this bill, many crucial air pollution standards would no longer apply. These include tailpipe standards for pollution from vehicles that produces smog and soot. This pollution harms heart and lung functions, leading to bronchitis, asthma attacks, strokes, heart attacks, and premature death. They also include greenhouse gas limits and fuel economy requirements for vehicles. Moreover, they include state and local requirements to periodically check that pollution control equipment is functioning, termed inspection and maintenance programs. Without these programs, the tune-ups that may be required, pollution control equipment won't necessarily continue to work over the life of the vehicle. I won't oppose this amendment. It's a step in the right direction, but it still does not satisfy me, and I'd be happy to yield my time to.
Thank you, Mr. Waxman. I look positively as well on this amendment, which lowers the number of vehicles that may be produced without meeting NHTSA vehicle safety standards under the proposed exemption. And as you said, I believe it is a step in the right direction because it would put fewer unsafe cars on the road than the bill otherwise would. But it, as you said, it would also not do anything to further reduce the number of vehicles that can be produced without meeting clean air standards. This is a small fix to just one of the bill's problems. Even with a reduction, we will still end up with thousands of vehicles on the roads that aren't meeting up-to-date safety standards. This amendment merely diverts attention from the bigger issue. H.R. 4013 is a flawed bill that puts the interests of a class of vehicle owners above the safety of our roads and the quality of our air. Neither will I oppose this amendment, but I will oppose the bill.
Reclaiming my time, I just want to point out that this amendment sounds so reasonable. You take 1,000 and you say 500. Why are we complaining about 500 vehicles? Well, that's 500 vehicles per manufacturer. And there's no limit to the number of manufacturers. We're going to encourage more manufacturers because I want to get more of these vehicles out. And that's for the safety standard. But the emission standards could be, I think, as 5,000 cars per manufacturer. So there can be a lot more manufacturers for those cars that will violate the emission standards. I know we want to encourage hobbyists. I know we want to encourage the ability of people to do what they want to do. Well, but it's not just them. We are going to have to pay. They're not necessarily the only ones who are going to get hurt in a car crash, and we're going to have to pay for the consequences often of the car crash, even if it's they who suffer from it. And they're not necessarily the only ones in the car who will be hurt. So I still want to point that out, that the bill is, underlying bills, in my view, not ready for me to support, and I would urge a no vote on the bill. Yield back my time.
Gentleman yields back his time. Any others on the majority side wishing to seek recognition? Seeing none. Any on the Democratic side, minority? Seeing none. I'll call a vote on the Upton secondary amendment. All those in favor say aye. Aye. All those opposed say no. In the opinion of the chair, the ayes have it, and the amendment is adopted. Now, if there's no further secondary amendments, the vote occurs on the amendment in the nature of a substitute as amended. All those in favor? No, this is just on the substitute. All those in favor shall signify by saying aye. Aye. All those opposed? No.
No, and I would like a recorded vote. Oh, I'm sorry.
On the substitute. Okay. So, in the opinion of the chair, the ayes have it on the nature of a substitute amendment. Now on the bill as amended. The request has already been made for a roll call vote, so we'll just bypass and go straight to a roll call vote on the bill as amended. The clerk will call the roll.
Mr. Lance. Mr. Lance votes aye. Mrs. Blackburn. Mrs. Blackburn votes aye. Mr. Harper. Mr. Harper votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Billrakis. Mr. Billrakis votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Long. Mr. Long votes aye. Mr. Barton. Mr. Barton votes aye. Mr. Upton. Mr. Upton votes aye. Ms. Schakowsky. Ms. Schakowsky votes no. Mr. Sarbanes. Mr. McNerney. Mr. McNerney votes aye. Mr. Welsh. Mr. Welsh votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Mr. Dingle. Mr. Dingle votes no. Mr. Rush. Mr. Matheson. Mr. Matheson votes no. Mr. Barrow. Mr. Barrow votes aye. Ms. Christensen. Mr. Waxman. Mr. Waxman votes no. Chairman Terry. Chairman Terry votes aye. Mr. Chairman, on that vote, there were 15 ayes and 6 nays.
The chair calls up H.R. 4450 and asks the clerk to report.
H.R. 4450 to extend the Travel Promotion Act of 2009 and for other purposes.
Without objection, the first reading of the bill is dispensed with, and the bill will be open for amendment at any point. So ordered. Are there any bipartisan amendments to the bill?
Mr. Chairman, I have an amendment at the desk.
Is it a bipartisan amendment?
It is a bipartisan amendment.
Therefore, the clerk will report the amendment.
Amendment to H.R. 4450 offered by Mr. Billrakis of Florida.
Thank you. Mr.
Reading will be
Chairman,
dispensed with and the amendment
go ahead and read it.
handed out. The gentleman from Florida is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, on behalf of Mr. Welch and myself, I have an amendment at the desk. This amendment strikes from current law the authority for Brand USA to impose an annual fee on U.S. members of the international travel and tourism industry. When the law was initially drafted, Brand USA was given the legal authority to assess fees on industry to accumulate up to $20 million. However, since Brand USA's inception, stakeholders in the travel and tourism community have recognized the value of Brand USA and have voluntarily provided overwhelming support, nearly $130 million in fiscal year 12. It's outstanding. That just shows you how successful the program has been. This assessment authority has never been used. Both the Brand USA and the private sector have indicated that they have confidence that private support will continue for Brand USA's mission and that legal authority to assess fees on industry is unnecessary. To maintain the voluntary private sector contribution system that supports Brand USA, I urge support of this amendment, and I yield back the balance of my time. Thank you.
Gentleman yields back. Anyone else wish to time? Gentlelady from Illinois is recognized.
Well, I will not oppose the Bilirakis-Welch amendment. I think we should recognize the possible impacts of eliminating Brand USA's ability to assess the industry. As I said yesterday, I recognize the huge importance of Brand USA, both nationally and to my own district, which depends on the jobs and revenue that visitors bring into the greater Chicago area. Travel and tourism inject billions of dollars into the American economy every year, and Brand USA plays a vital role in encouraging more foreign visitors to come to the United States. That is why it is so important to protect the long-term viability of Brand USA. Brand USA has done well to raise needed private sector contributions to sustain its efforts. However, as the Department of Homeland Security's needs increase, it seems possible that federal funding could be reduced in the future, requiring additional industry support. Eliminating the assessment means that Brand USA could one day lack the resources needed to meet its goals, with no mechanism in place to raise needed capital. The U.S. travel and tourism industry and our entire national economy needs a strong Brand USA, and removing the assessment authority could have negative consequences down the line. And I yield back.
Anyone else seek recognition on the Bilirakis amendment? Gentleman from Vermont's recognized.
Well, this is a good bill for all our districts. Mr. Bilirakis, I really appreciate taking the lead on this. Florida, huge tourism industry. Vermont, a much smaller state, but the tourism industry in Vermont is incredibly important to Vermont. It's like 20,000 jobs. A lot of kids get their first job in the tourism industry. It gets that foothold in the labor force. So I thank Mr. Bilirakis for his really good work on this, and am in support of this amendment. I yield back.
Gentleman yields back. Any further? Anyone seek recognition? Seeing none, we will. All those in favor of the Bilirakis amendment say aye. Aye. All those opposed say no. In the opinion of the chair, it's a unanimous. Ayes have it, and the amendment is adopted. Any further amendments? Gentlelady from Illinois.
Yes, Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 4450, offered by Ms. Schakowsky of Illinois.
Gentlelady, dispense with the reading and hand out the amendment, and the gentlelady is recognized for 5 minutes on her amendment.
I would again like to thank Mr. Bilirakis and Mr. Welch, the sponsors of H.R. 4450, for their continued commitment to the promotion of international tourism. I strongly support the mission of Brand USA, which creates jobs and revenue for communities all over the country. This bill already makes several positive changes to the program, and I'm encouraged by those improvements. I believe that there are additional ways we can help ensure the success of Brand USA long into the future. My amendment would make the program even more accountable and transparent moving forward. The amendment has several objectives. It includes several accountability recommendations, mostly from a Government Accountability Office GAO report from 2013 on Brand USA. The amendment would direct the Department of Commerce to establish specific publicly available timeframes and conditions for revisions and resolution of disagreements related to its in-kind contribution policy. Having a set policy will not only promote greater transparency, would also, in the words of GAO, quote, enable productive interactions and facilitate collaboration, unquote. The amendment would also require Brand USA to report annually to the Commerce Department and the public with explanations of a single expenditure over $500,000 instead of the $5 million limit in current law. And lastly, the amendment would expand upon the bill's sponsors' efforts to more effectively monitor the performance of Brand USA. GAO has suggested that Brand USA be directed to develop a plan that specifies timeframes, methodologies, and data sources for measuring its performance and the campaign's impact. By requiring those criteria explicitly and by adding specifics on certain basic items it should measure, this amendment would give Brand USA more direction on the type of information it should collect and ensure that its metrics are effective at determining the success of the program. Brand USA's continued long-term success is essential to communities that, like my district, depend on the economic benefits of travel and tourism. Brand USA is off to a good start, and I applaud everyone involved for their ongoing efforts to encourage people from all over the world to enjoy everything America has to offer. And I hope that with this bill and with my colleagues' support, this amendment, Brand USA will continue to be a responsible and successful force in the future. And I yield back.
Gentlelady yields back. Anyone else seeking attention? Gentleman from Florida, for what purpose?
Thank you, Mr. Chairman. I'll accept the
gentleman is recognized.
With the revised amendment, with the stricken language with regard to the adjustment of the in-kind ratio. Otherwise, I will accept this particular amendment. And I will support it.
All right, gentleman yields back. The question now occurs on the amendment. All those in favor of the Szynkowski amendment, say aye.
Aye.
All those opposed, nay.
I'd like a roll call vote.
Really?
Oh, no, not on. Sorry.
Okay. In the opinion of the chair, the ayes have it. The amendment is agreed to. Now, any other amendments? Seeing no request for amendments, the question now occurs on forwarding H.R. 4550 to the full committee as amended. All those in favor say aye. All opposed say no. In the opinion of the chair, the ayes.
On that, I would like see, I've had 2 cups of coffee. Maybe that's too much. So I would like a roll call vote on final pass and our sending it to the full committee.
Very good. There is a request for a recorded vote. The clerk will call the roll.
Mr. Lance. Mr. Lance votes aye. Mrs. Blackburn. Mrs. Blackburn votes aye. Mr. Harper. Mr. Harper votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Billrackus. Mr. Billrackus votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Long. Mr. Long votes aye. Mr. Barton. Mr. Barton votes aye. Mr. Upton. Mr. Upton votes aye. Ms. Szynkowski. Ms. Szynkowski votes aye. Mr. Sarbanes. Mr. McNerney. Mr. McNerney votes aye. Mr. Welsh. Mr. Welsh votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Mr. Dingle. Mr. Dingle votes aye. Mr. Rush. Mr. Rush votes aye. Mr. Matheson. Mr. Matheson votes aye. Mr. Barrow. Mr. Barrow votes aye. Ms. Christensen. Mr. Waxman. Aye. Mr. Waxman votes aye. Chairman Terry.
Aye.
Chairman Terry votes aye.
Clerk will report the result.
Mr. Chairman, on that vote, there were 22 ayes and 0 nays.
Well, that's a great vote, and the ayes have it, and the bill is agreed to. And without objection, staff is authorized to make technical and conforming changes to the legislation approved by the subcommittee today. So hearing no objection, so ordered. And also without objection, no further business before the subcommittee today. The subcommittee stands adjourned.